Now I'm going to turn and welcome you to today's class on open juvenile courts. As everyone in the room already knows, as of January 1st, 2010, there was a significant change in Georgia law, and maybe today we'll comment on whether it's significant or just a change in Georgia law regarding deprivation court cases in Georgia. And we are very fortunate to have with us two judges to talk to us about what this change means to us. We have Judge Velma Tilley from Bartow County Juvenile Court. She was a SAG in private practice before she went on the bench in juvenile court several years ago. During her career, she has served on the Permanency Planning Committee with the Georgia Council of Juvenile Court Judges and has been integrally involved in a lot of the work around implementing federal laws around permanency planning for children. So we're very glad to have her here with us today. And she also wants everyone to know that her most rewarding career job has been working with juvenile court. So in addition to parenting and her family, the juvenile court work has been the highlight of her work. Also with us is Judge Britt Hammond of the Toombs Judicial Circuit. He also served as a SAG. I have that correct, right? He was listed as the agency, and I want to make sure. He also served as a SAG, so it's a great perspective that we have him on the bench also as a juvenile court. Like Judge Tilley, he has done a lot of work with the Council of Juvenile Court Judges, has served on the Permanency Planning Committee, worked on the committee within CJCJ to implement this new law, and they're both here with us today to share their perspectives and information about this. Please welcome the judges.
Good afternoon. Judge Hammond and I are here and pleased to be here to share some ideas about open juvenile courts. Today is the 27th of January, so they've been open for 27 days. You know, there's not a whole lot we can tell you about our experience with open courts yet, I guess.
That's true.
But we're going to do the best we can on that. He's been kind enough to let me speak first, and he should not have put my name up on this PowerPoint first because he has done the vast majority of the work on this. He did all the research. He's really prepared it all, but he's been very kind and he should not have put my name first. And the reality is I shouldn't be speaking first, except I asked if I could say this. When this law was passed, I thought the sky would fall. I was really horrified about it. But the truth of the matter is it hasn't fallen. And and there are a couple of reasons. One, I think when I didn't go to the legislature much last year, I'm really kind of glad about that. I was signed up to be judge of the day 3 times. I didn't have to go any of my days. I got the call that said, we don't need you today. And I thought, oh, great. I got credit for signing up and being willing to go, and I didn't have to go. But I wasn't needed. So when this came up, I wasn't in the loop on whether I needed to go, so I didn't go. I think the first draft was pretty wide open and did not provide much protection for children. But through the work of some folks from the Council of Juvenile Court Judges and from other agencies, some protections were put in that do provide for protections that I think were needed so that children and families are protected from wide openness that I think could have been problematic. And I'll say this, you know, one of the things I was most worried about, I would say would be the category of, say, middle school, late elementary school children who are typically humiliated by their parents under the best of circumstances and would be humiliated and further traumatized by having people realize what their parents have done either to them or to their siblings, and have their schoolmates know about it, have their neighbors know about it, and how devastating that would be to them. And I mean, I just was particularly worried about that segment of the population. But I think there are protections that are built into this law where we can protect children. And so I'm really not concerned about it. And in fact, when the law was passed, I just decided to go ahead and kind of open my courts anyway. And who I opened them to, I really could have opened them to before, and that was to family members and folks who had an interest. And I basically kind of encouraged that and said, if nobody really objects, and first, you know, the state might have objected, but I basically said, let's have the family members in. And what an eye-opener. And what I found out was how beneficial it was for families to know what the truth was. to hear what was happening in their child's case, their child being the parent, and how that actually moved children to permanency faster, sometimes with those family members, and sometimes not. But that was eye-opening to me. And so I became much more open to the concept and still realized that I can protect children and families with more openness. And I spoke to one of our Rotary clubs on Monday, and I told them that the court was open, and we had a member of the press there, and she was actually a member of the radio press, and I said, I meant to call you, Ernestine, before the courts were open, so I could come on the radio and tell everybody about it, so then you could forget about it, and you wouldn't come, because I really wanted it to be known, and so I was telling the Rotary, and so the fact is, I'm having a hearing tomorrow, and that was yesterday. It's a pretty bad case. It's not open tomorrow, but if we go past tomorrow, it will be open. But before you decide that you want to come, and then I gave my pitch about, and I said this, I don't care if the press comes to every hearing I have. I'm not worried about that. And in fact, though, and I did say how having the press there, having really the public there, might improve something that I do, and I'll tell you about that in a minute. But before we have just casual people coming to see what's going on, think about whether your sister got involved with somebody that you wish she hadn't, and maybe it's an abusive relationship. Or think about your daughter, and about whether you want that humiliation, whether you would want the public viewing that humiliation in your family. And they're all sitting there looking like this. And so that was kind of my pitch, to kind of keep out casual observers in people's most private and most vulnerable, the most, vulnerable times of their life. And I said, I was saying that perhaps with a little private moment with your sister or your daughter, we might get her to make a better decision about her life. And so that, anyway, but they now know, the entire Rotary Club, 40 or 50 of them, know that we have open courts and are essentially, and the press, that they're invited to come. I did say this, however, and it's actually true of how this presentation might go to some, it's back when I was a SAG, and I guess all of you know what SAGs are, Special Assistant Attorneys General. As long as I made a disclaimer about that I was only speaking for myself, I could say some pretty wild things. I could be forceful, and I could get on my soapbox, and I've mellowed out as a judge, some, but I'm going to be even more mellow now that this is going to be webcast. The same would be true. I told them at the Rotary, sometimes I'm harder on people than I perhaps ought to be, particularly boyfriends that mistreat children, boyfriends of mama. And I used to have a sign on my bench that said, treat everyone with courtesy and kindness, to remind me that I needed to treat even people that were horrible with courtesy, and judges need to do that. I mean, the judges I respect most are those who never get agitated by what the facts are, and the facts in our courts are terrible, as you know. And I thought, when it's just us, and it's the boyfriend sitting there, I might be hard, but if I have the public there, and if I have the press there, I might remember that a little bit better. So that's what I was going to say. Judge Hammond and I are probably the fastest talking judges in...
I know. I was wondering who was going to be good cop and bad cop. We're both high-strung and talk fast. You're in trouble.
So we're going to try and talk slowly, but he's going to go through the PowerPoint he's presented. We do want you to ask questions. We do want it to be interactive. But if you raise your hand, we'll get that microphone to you. So, Judge Hammond.
Thank you, Judge Tilley. Well, we had hoped when they asked us to do this that we would, we tried to put it off as long as we could just because we wanted to have some war stories to tell you, but we don't have a lot. I've been talking around the state and kind of trying to keep track on this, and it hasn't really been a major issue yet that I can see. You may be aware of something. If you are and you want to share it now, please do, and if you don't, tell me afterwards. I still want to know. But we're going to talk a little bit, go through the law, how it was before and how it is now. We've got some discussion points at the end to try to stimulate some discussion amongst us and just see. But please, let's make this as interactive as possible. Well, as you know, the former law is 1511-78, and under that law, we had presumptively closed hearings, okay? Except as otherwise provided, the general public was excluded from delinquency, deprivation, or unruliness hearings. In those cases that it was presumptively closed, who were permitted? Well, the parties, their counsel, witnesses, persons accompanying a party, or people who had a proper interest who the court would allow in. Children were also permitted. They could be temporarily excluded unless there were allegations of delinquency and unruly being made. And you know, the seminal case in this area was Florida Publishing Company versus Morgan, which basically said that absolute closure violated the Constitution. That if the press wanted to come in, they had to be given the opportunity to show that their interest, the public's interest in knowing, would override the privacy interest involved. So we did not, I guess in Georgia, we've never had absolute closure. There's been the ability to get in. There were exceptions to that general rule, and it involved an adjudication involving a designated felony. They were open. An adjudication hearing involving an allegation of delinquency brought against a child who had previously been adjudicated delinquent. Now note this though, because this actually survived. The court is instructed to close any delinquency hearing on an allegation of sexual assault or involving substantial evidence of matters of deprivation. That is in the current law as well. It's a little bit interesting because what we're going to see in a minute is that what's happened is the exceptions are now the general rule with the addition of deprivation proceedings. But that survived both. Of course, child support hearing, legitimation action, and at this court's discretion, any dispositional hearing. That was the former law. So what is the new one? Of course, it was signed on April 30th, 2009. It amends 151178. The purpose was to admit the general public to certain proceedings, and it has certain exceptions. Here's something important to note. The effective date of it was delayed until January 1st of 2010. So if a matter was filed before that time, then it is not under this law. But that's not as clear-cut as it can be. You want to comment on that?
Sure. Yes. You know, the law doesn't say that. As you know, it doesn't say this applies only to cases filed after January 1st, 2010. But courts, some courts, and I don't know if all courts, but courts are interpreting that to be it applies to petitions filed after January 1st. And there's a basis for that in that when the law changed as to appeals being filed, termination of parental rights cases not being appealed directly but having to be appealed by application, an appellate court case came down and said that only applies to those cases that were filed after the date the law came into effect. So by taking that same reasoning, courts should perhaps interpret this law the same way. So the law being, it applies to, if this case came into effect January 1st, 2010, it will apply to deprivation proceedings, petitions filed after January 1st, 2010. So theoretically new cases. On the other side of that, it would mean new petitions. So it could be an old case because it could be a petition filed, meaning in my interpretation would be a second extension, or it could be a termination petition filed after January 1st, 2010. At the back of your materials that you have, Judge Sumner from Cherokee County has a list of his court procedures, and it looks to me like he's applying it to motions for extension. So it sounds like interpreting motion and petition to be kind of the same thing, just making, he's kind of saying the form, it doesn't matter what you call it, it sounds like he's considering that to be a petition. So I'm going to consider a petition to be a petition and different from a motion. So whatever court you're in, find out what your court is, how your court's going to apply it. But certainly if it's labeled a petition is a petition. Be hard to argue around that.
We certainly want to thank Judge Sumner for providing that. What you have in your materials is his local operating procedure for Cherokee County and some forms, which he was gracious enough to share with us. That's just for your information. And as you see, there could be some different interpretations of this in this matter. It's going to eventually work itself out no matter what. But those materials are there, and I want to give Judge Sumner a thanks and credit for doing that for us.
We sure do.
Now the law is that the hearings are presumptively open. So the general public shall be admitted to all of those hearings that were listed as exceptions, with the addition, as I mentioned, of deprivation proceedings. Now, the definition of deprivation proceeding, I think, is pretty broad in the sense that it's a court proceeding stemming from a petition alleging that a child is deprived. You know, at one time there was some discussion about, well, does it apply to termination petitions? But, you know, the first element of termination is a deprived child. So I think that's pretty broad, and it seems to me that the intent is to make it broad, to apply across the board to that. You have any comment on that?
Well, the next thing I want to say there is I didn't really think about what the actual definition of a deprivation proceeding was. I was thinking, you know, when January 1st hit, I was admitting people to the 72-hour hearing, just because I just considered it's open, you can come in. Well, we didn't have any public coming. We just had family anyway, and I was already admitting family. But in preparing for this presentation, all of a sudden I see, oh, petition. Petition is in fact different from complaint. And there's a good basis for not admitting folks to a 72-hour hearing, because we may never get to a petition. It may all be dismissed at the complaint stage, and you know that would really be horribly unfair to folks to have all of this kind of dirty laundry aired and then nothing come of it. So note that it is not 72-hour hearings. It's after a petition is filed. Of course, well, that's all. If once a petition is filed. Now, if somebody files a petition at the same time and the petition is filed at the time you have a 72-hour hearing, well, it's open. So.
All right. There are exceptions, of course, as Judge Tilly alluded to earlier, that there is the ability under the law to actually move for closure, okay? But there is a very prescribed procedure for doing that. And the court is only allowed to close upon the following: making a finding upon the record, issuing a signed order as to the reason or reasons for closing all or part of the hearing, and stating that either the procedure involves an allegation that would constitute a sexual offense or is in the best interest of the child. This is kind of the issue that causes, I guess, judges to really cringe a little bit, in the sense that it has the potential to cause a delay, and that's something that we just trying so hard to move cases through to get kids on to permanency. But this matter must be taken up prior to. Now, it can be taken up as part of the same proceeding, or there is potential there that you actually have a long hearing on it that might delay. And when is that matter brought to the court's attention? I mean, the thing that scares me or concerns me is, on the day I've got something scheduled and I've got all these expert witnesses, somebody flies in and wants to be admitted, and then somebody objects. And that's the kind of part of it that's really kind of has concerned me, but it hadn't been an issue yet. You have a comment on that? Whatever?
Well, we haven't had any. If there's been one in the state, I don't know about it, and maybe there has been. But nevertheless, we have to have my thought was, you don't necessarily have to have the signed order before you can go on. But in case you do, some of us have prepared handy-dandy orders ready to go. And I'm kind of known as the queen of the form order. And you have an order in your packet that I've prepared, which has lots of fill-in-the-blank parts. And it has a typographical error in it, which just kills me. But it's because I've never used it yet. So I haven't been able to weed out my typographical errors. And that's on page 2. At the top.
It's
3
my
lines
fault.
down. No, it's not. It's not your fault. It's not. And the effect that closure is necessary to protect the privacy of the child. Take out the effect. It's and that closure is necessary to protect the privacy of the child. But nevertheless, if you have an order that outlines everything the judge is supposed to consider, there it is. Fill in what the considerations are and make the decision. So the idea is, here you have a possible form that you can fill out right there once you've had your hearing, file it, go on with your hearing.
I'll say most of the judges that I've talked to about this are taking the approach that they're having a form order ready in case this issue does arise so that it can be issued and there's no problem. That seems to be the majority approach so far. Now, if you state under 2 there that it's in the best interest of the child, there are required considerations that have to be addressed, such as the age of the child, the nature of the allegations, the effect that the open proceedings will have on the court's ability to reunite and rehabilitate the family unit, and this is kind of a broad one, whether closure is necessary to protect the privacy of a child, of a foster parent, or other caretaker of the child, or a victim of domestic violence. That's pretty broad. I know you have a thought on that.
I would like to have some conversation around this. Certainly that is broad. I mean, and that's, the concern I had was about protecting the children, the privacy of the children. It seems to me pretty easy to protect the privacy of a foster parent in that if that's a real issue and a foster parent is really balking, then you might close it while the foster parent testifies or, I mean, in small towns that is really an issue. I mean, they're easily identified, and then you bring everybody back in after they're not. But I wanted to discuss this issue of about victims of domestic violence. And I recognize that I may need a lot more education about domestic violence. And I've gotten in trouble in other conferences before about talking about this issue. In that, while I'm personally very concerned about victims of domestic violence, what we have in juvenile court are victims of that. The children are, in my view, the greater victims. And because what we know about statistics in domestic violence, which is that the adult victim of the domestic violence so often goes back to the abuser, we have a problem in dealing with the children. And in another conference I stated, I'm going to protect the children, and I'm going to remove the children if I need to protect them. So here we have again a highlight about protecting victims of domestic violence when it seems to me that spotlighting an abuser in that kind of relationship in public might be beneficial. Dead silence. Any thoughts on that? Why is it so necessary to protect that segment? In all that we do in our court, why are we going to be so concerned about protecting a victim of domestic violence who is so likely to go back to an abuser? Okay, wait a minute, we need a microphone. Thank you, hold on. You weren't here when we said we have to have a microphone. Thank you.
Well, I understand that that's what statistics say, but that's a big presumption that they're going to go back. And in the event they aren't going to go back and they're truly trying to rehabilitate or get away from that abuser, a lot of times victims of domestic violence are embarrassed about their situation, and maybe that's the reason they put it in there, because of the embarrassment. And if they truly are trying to rehabilitate themselves and they aren't going to go back to that abuser, then there would be an interest in protecting them.
So should we let the public in on the second time for this person?
At the next hearing, you mean?
Right.
Well, no, it would still be the same interest.
No. Okay. Yeah, I mean, I hear that.
Uh-huh.
But the problem is, we're opening courts for scrutiny, for accountability. Is it only accountability of the judge that we're talking about in open courts, or are we talking about accountability of parents, or just defects, or lawyers and guardians ad litem, or I mean, is it everybody who all is to be accountable? Okay, we agree everybody's to be accountable. Okay.
Can we go back to the comment about how many times before we protect the victim?
Okay.
Because if we're talking about a defects case, if we're seeing it as a petition and being brought in, well, the department had to have made reasonable efforts before they came. So if we're having to bring a failure to protect case to the court, Haven't we already dealt with that? And it's clear that that victim wasn't accountable on her own through the safety plan methods, through the case plan methods, and so now you're actually have to bring it into the court. So,
That's a
Velma,
reasonable
I agree with you. I mean, if we're having to be in court, they didn't do it on their own.
That's a reasonable argument. Hopefully that happens.
Thank you, Judge Mance.
Thank you. This gentleman, thank you.
I had a question regarding the privacy or protection of the victim of domestic violence in the sense of what kind of incentive are we giving the person who's in the situation for domestic violence, the victim, so to speak?
What kind
If
of
we're
what?
embarrassed, what kind of incentive are we giving them to actually, say, work their case plan and walk away from the situation or the abuser if we're trying to embarrass them? And it's kind of like, if I'm embarrassed, I'm more likely to not want to try at all.
To me, that applies to all parents. I mean, that was kind of my concern about opening the courts to begin with, that we are trying to help families, and the humiliation of folks coming in and substance abusing parents, parents who, for the vast variety of reasons that parents come to juvenile court because they're not doing right by their children, all those arguments apply to them as well as to victims of domestic violence.
Because I thought the purpose of the bill was opening up the courts to actually hold the system accountable versus the actual people involved. Whereas, say in the case of a father who probably hasn't been taking care of his children or paying child support, it's basically an embarrassment. So therefore, I'm not going to show up. I'm not going to be there if that's going to be the case. So I think it's kind of a double-edged sword of, holding the system accountable, but at the same time, you're shedding light on someone who may be too embarrassed to show up. Like, what's the incentive for a father who is in that situation to actually show up if that's the case?
Well, I'm concerned about public humiliation. I'm concerned about that. What I'm saying here is we've set aside, and I don't want to be the only one talking, we've set aside a particular group that we're not going to embarrass. And I'm wondering why we're setting aside that particular group only.
Let me just interject. We're going to talk a little bit more about, in the end, some discussion points about things. And I think, as far as humiliation, let me just go ahead and kind of preview what my last point is, and that is, we are responsible for this.
We who?
Those of us in juvenile court, those of us, attorneys, judges, everybody. This is our court. This is our system. We're going to have to guard it jealously against things that do humiliate people. If we really take it serious to reunite families and to work with them, we're all going to have to be jealously guarding that system and make sure that we don't stray over into these things. And we'll come back to that in just a minute. I'm sorry.
One more question, and then we'll get on.
Judge, I can think of a time when if a mother is in a relationship with a boyfriend who's not the father of the children, if the boyfriend is being abusive and she decides to leave that boyfriend, I would definitely think you would want to close that hearing if he may have the opportunity to come to that hearing and find out, where she's living, find out information about her, follow her from the hearing wherever. She's maybe simply in your court for lack of housing because she had to leave him because he was being abusive, or lack of job, something like that. But not necessarily because she failed to protect. But in trying to protect, she ended up with these other issues.
Oh, no question.
I could see where that would be
Absolutely
a good time to do that.
I was really thinking about him being the father of the child, but that's an excellent point. No question about it.
A party at all, but
Right. Absolutely. No question about that.
I didn't mean to jump the gun. You got anything else you want to add?
No, let's go on, and then we can come back to that thought if we have time at the end.
All right.
Thank you for your participation.
Who can move to close or exclude from a hearing, and is the court, a party, the child's attorney, or the guardian ad litem can all make a motion to actually have the hearing closed or to exclude a particular party. Now, who may be admitted if it's closed? It flips back to the former law, okay? If it is closed, then we go right back to the way it was, that parties, their counsels, witnesses, persons accompany them, and persons the court finds of interest. Those are the persons that are allowed into the system. Now, there is this exception if it's closed. If there's conduct alleged that could give rise to a criminal or delinquent prosecution, then attorneys for the defense and the prosecution come in. I've referenced here a case for you that arose under the former law where an attorney made an argument that allowing the prosecutor in to these deprivation proceedings was violating the law, and it prevented the free flow of information. It hampered her client or his client from sharing and from getting full participation in that. And the judge had allowed it. Well, the Court of Appeals said that was fine. The judge had discretion to do that. So now we see that kind of codified into the new law. I just put that out there for your examination. Now, we also have the ability to refuse admittance to an open hearing, okay? The court may refuse to admit a person upon making specific findings and issuing a signed order that it would be detrimental to the best interest of the child, impair the fact-finding process, or be otherwise contrary to the interest of justice. Did you have a comment?
No, but that's the point this young woman was making, that that person needs to stay out. You know, this particular person in particular needs to not be admitted to a public hearing.
And I think and really, in my mind, it raises our due diligence. We're going to have to really be diligent in looking who may be out there and watching that for something just such as that. I mean, one of the concerns that I heard amongst judges is, what about predators? What about children predators? Something, you know, coming in. We're all going to have to be diligent in watching that and being careful. Now, the child can be temporarily excluded from a hearing except if there are allegations of delinquency or unruly conduct are being made. Then the child has to be present for those.
Can I bring up something just here on this? That was a concern, the idea of predators. And one of the thoughts, the conversations had amongst judges was, so what do we do about that? Do we have the clerk at the door start taking people's names and having them sign in or show an ID? And a long time ago, I was a school board attorney, and it seemed to me there was a law that said you can't require that of people. You cannot make people identify themselves as in an open hearing. That chilled the process. And so I don't remember if that's the case or not, but that was my recollection from about 15 years ago. But, you know, that was a concern, but some of the other judges didn't think that was a problem, you know, getting people to sign in. You know, our courtroom is so small, you really, you know, if you get family in there, we're pretty much full. So I don't know that that'll be a problem. But when you think about that these are our most vulnerable families, this would be a hunting ground for folks that want to take advantage of people. And, yeah, it may be far-fetched to think that that's going to be a problem, but maybe it's not far-fetched in some instances. So we just have to be aware, you know, kind of get an idea of, you know, if we have somebody that doesn't seem to have, you know, that isn't a concerned citizen, you know, we can have watchdog folks in there, that's fine. We can have the press in there, we can have family members there, but if there's somebody in there that we don't really know who they are, we need to kind of be paying attention to make sure that our families are protected and our children are protected. It's you. Oh, sorry, that's right. Judge?
Thank you, Judge Tilley. I have two questions. The first one sort of goes back to where everyone was before. Are we using initials anymore, or initials out? And if initials are out and we're using children's names, when is it ever not in the best interest, or when is it ever in the best interest of a child for their name to be disseminated so that these people that are coming in, press, family members, non-family members, interested citizens, and now children who are the true victims to everything are now publicly displayed for everyone to know who they are and what's going on in their lives? And that may very much be a rhetorical question, but that's something that's been bothering me, because we just had a situation the other day where Judge Walker was telling our clerk to just go ahead and say the name of the next case because you don't have to use initials anymore.
Okay, Sandra, this is a question for you. Oh, she's stricken. Mike, don't anybody look at her.
Okay.
But you know, we had a case where I said, you know, they probably sounded the last name. Did y'all sound the last name of the child when you asked who was here for the blank case the other day? When we had all those family members here, the answer is yes. You just said, y'all said the last name of the child. Okay.
But where is that? How is that not in violation of the best interest of the child?
This is kind of highlight. We'll come to it in just a minute. This is kind of highlighting one of the issues where, there's really not any regulation of it. For example, this law, a lot of the background of it came from Minnesota, and they had the open courts there. And the group, the Better Courts for Kids organization, that was a main sponsor of this, and we have several of my Better Courts friends here today. I'm glad to see y'all. They used that. They looked at that model very intently. And what Minnesota decided was they were going to have to educate the press on kind of what is ethically okay in juvenile court. That's not built into this. And so we're kind of on our own with kind of trusting people to protect. The press. Now there's going to be a provision where you can keep the press from releasing identifying information, but somebody that walks in off the street, they're not under that.
MySpace.
Yeah, and these kids do it. I mean, when I'm talking about delinquency, my delinquency calendar, what the dispositions on that are up on MySpace before I get out of court. That they already know.
But what we're going to do, actually, and I've been meaning to do it, I haven't done it yet, but we're going to have a sign on our door that just says, "Court open, please enter quietly," or "Court closed," and the door will be locked, or "Please don't enter." I haven't gotten around to asking my clerk to order the sign yet. But for those that have been open, we've just announced the name, and so far it's just been family.
My second question goes back to who can move the court to close, and two groups come to my mind, and one is CASA. Our CASA, of course, is very active in Douglas County. Where is their ability to ask? I guess under the child's attorney or guardian ad litem. And the other thing is, what about a third party who has custody of the children, not necessarily a foster parent, because I presume that the SAG's going to ask on behalf of the foster parent, but if you had a relative who has custody of the children.
Yeah, that's a great question. I've been going around the state talking about this, and I raised that issue. I said, what about if you do have a third party or a foster parent, where that's a consideration. They want it closed. Who is their advocate? And really the response, I don't have an answer, but the response between the parents' attorneys and the attorneys for the children was, we're not going to do it. And I said, well, what if they say, your child's in a stable placement? And they say, if I've got to go into open court and do this, I'm out. I'm done. What are you going to do then? They didn't really say. But, if it could affect the stable placement child. I don't know how that's going to be handled. I asked some judges that too. How if a foster parent comes in, how are you going to handle that? Are they going to have an attorney? Or what? Are you just going to listen to what they say? We know they have the right to notice of the hearing, and they have the right to be heard in the hearing. So we know that's built in, but I don't know the answer to how that's going to be handled. I think it's unanswered by the law.
I have a suggestion on that. Since the foster parent or the caretaker has a right to be heard, the way they need to be heard is at the beginning of the hearing to say, "Court, I think this hearing needs to be closed," and then the court needs to hear that at the beginning of the hearing, so the court then makes the motion.
Yeah.
That's the way to get. To me, that's the way you get around that.
That's a good idea. Yes, ma'am. 1 second. You good?
Judge Till, I wanted to go back to something you just said. You said that you would have a sign out that said court open or court closed.
No, I don't have it yet.
No,
I'm going to have it.
But if I wanted to come and hear a case in your court and I show up and that sign that says court closed is on the door, how would I find out your reasoning for closing that court?
I guess you could, thank you for bringing that up. I guess you would ask my receptionist. And then her answer would need to be, it's a delinquency hearing, or it's a it's a 72-hour hearing, or she would have to just tell you that. She'd probably have to call in to find out what we're doing, because she's generally probably not going to know.
But if it's a deprivation case, then you should already have a signed order as your reasoning, right?
Well, it may just be a 72-hour hearing. So
but if
wouldn't
it
be
was, if it was, if it was a petition case past the 72-hour.
Then there should be a signed order.
Okay.
Right. Are you making notes, Sandra? So we.
That was a good one.
My clerk's here, so all these ideas are coming back. That's good. Nope. Just don't ever turn it off.
Okay. Along those same lines, if there is an order that says the hearing is closed and the person is asking, can they have a copy of that order? In our court, Judge Walker has said the hearings are open. So if anybody calls me, asks information about a case, I don't have to give that to them. It is just the hearing. So if someone's asking why a particular hearing is closed,
Yeah, that's a good question. You know, because we're gonna come. I tell you what, can we hold that for just 1 minute? We'll talk about inspection of records in just 1 second. You write that down.
I'm writing it down.
Listen, I really appreciate these tough questions because the honest answer is some of these things we thought of, some we haven't. I mean, and we're just trying to work through them because it's a very new procedure for us. I mean, I guess your question is, how is it going to be published? Is the order going to be published or not? Basically.
Well,
and you're saying that you're not publishing it, right?
But what we have now, let's go back. We have a presumption that a hearing is open. And so that now, I mean, it used to be that no information was given over the phone unless the clerk recognized the voice. And it was apparent. And she knew, it's a she's a she, that, you know, and there would be, so occasionally she did know the voice. But if our staff does not recognize the voice and does not know they are a party, no information is given over the phone because they are private. It's all private. We don't give out private information. However, if something is presumptively open, the question is then, is it private anymore? So it sounds to me like the answer is we can give out information that a hearing is open.
But the deprivation record is not subject to public inspection.
But that's not the issue. The question is, we have an open hearing on the Smith case at 10 o'clock on Tuesday. I think that we give that information.
Yeah,
Wouldn't we give that information?
I think that's reasonable. That's reasonable. But I was thinking what she was asking was the order. The record is not going to be open to inspection, but can you give out information? I mean, I would agree with you on that, but...
and I know I don't have a microphone.
Yeah, go back to your question. I'll repeat the question.
Yeah.
Well, I think you got me with two questions now. My first question was, if Johnny neighbor comes in and says, I was here for this hearing, but it's closed, why is it closed? And he's just wanting to be nosy. He may not even know who the neighbor's kids are, but he knows that they're in court. And the answer is it's closed. Well, I want to know why. Well, we could generically say it's because the judge found it was not in the best interest of the child. But at what can we tell them about that, the reason it was closed? Can we give them a copy of the order that says it was not in the best interest, it was whatever the options were? But then the second question is what you're leaning toward,
Records
Judge,
are not open, so you
records
Right.
and information on the hearing, though. So I'm good with the records, but if somebody calls me and says, hey, I need to know if the Smith kids are in court on Tuesday at 10, I'm going to say, who are you? I'm going to start questioning them, or I'm just going to say juvenile court's confidential. But am I...
Well, I mean, in some sense, you're going to have, the law is going to require you to have that order there. It's going to be a part, I mean, this is what I would say, it's a part of the record, so the record's not open to public inspection. So when somebody comes and shows up and says, I want a copy of that order, I don't think they can get it. But I think you can certainly tell. You can, I mean, your
Only
idea,
the parties can get it.
Yeah.
Okay, it's January 27th. The law has been in effect 27 days. I guess some of this we're going to figure out as
No question.
See, isn't this great? Y'all have me back, right?
But see, you and I are getting a head start on figuring some of these.
Yeah.
I was just going to say on the flip side to that is if the whole purpose of this law is to hold the system accountable,
Right.
and there are strict instructions as to what is to be placed in the order for your basis for closure, it's almost like to follow along those lines, the order should be available.
But it isn't. They didn't make that change. For some, I mean, there was a lot of messing around with that record part during the legislature.
We will come back to that, too. We will come back to that, to the records in just a minute.
Well, we're going to get to it. We're not there yet.
We'll get that. If we can hold that, we'll come back to it. Yes, ma'am.
Okay, so it's January 27th,
Right.
2010.
2010. How many times has any of this come up in your court?
I've been asking that, and so far, I've heard
Well,
zero.
It
That's
came
what
up
I've heard.
in Cobb, right? Y'all had something.
But
in
we
Cobb.
do have-
surprise.
we do have somebody, somebody mentioned to me a Cobb case.
Of course. But. Okay. Did you get a copy of the order?
Can you get him a microphone? Hold on just one second. Hold on just one second.
Wait,
Yes, sir.
Well, I went there and I asked if I could see a deprivation hearing, and they said, sure. If you'll just have a seat, we'll call you when when the
When one's
hearing
open.
occurs. And so I waited over an hour, and they came and said, the hearing is closed. We're sorry. And I said, why is the hearing closed? And they couldn't give me a reason that I could understand. So,
Yeah, well,
apparently when it comes to the docket, the people that are managing the docket, they're not indicating which cases are open and which are closed.
Well, it's going to be a lot harder in metro counties.
Yes.
I mean, it's just going to be a huge problem. And I think Judge Sumner is handling it in what he says, I think he's doing his closed calendar at 8:30 or his open calendar
yeah,
at
he had it
8:30?
set up, he had it specified.
This was a TPR case, and so it would have been obvious that it didn't start.
It couldn't have
in
been, it couldn't have been
2010.
open anyway.
Well, yeah,
It could not
that
have been
one-
open.
Right,
would have
right.
had to
That's
been filed last
and that's
year.
what I'm saying.
Well, I can answer that one for you. It wasn't open.
Yeah,
Maybe
that
you-
one would have had to
They
be
were
filed.
required to give 30 days notice. It's the 27th of January. It couldn't have been filed on January 1st.
But you should have provided the information to the staff.
I'm sorry.
He's asking what
Well,
the
Yeah,
Bless 'em.
the judges could have provided that information to the staff ahead of time.
I can't,
give us a little bit.
I'm pretty
of a
sure my
break.
staff would have had a hard time with
Yeah,
that one.
yeah.
And we're not a
It's-
metro county.
It's been almost a month that the bill's been in
They're,
operation.
they're all waiting for this presentation to be webcast. But thank you. I mean, you're bringing this to our attention. The clerks are going to be, trained in April. And, I mean, we're doing,
Well,
thank
we're
you.
wondering about just how accessible the courts are going to be. We would like to have, let's say, for example, Kennesaw State University students attend the cases, and
Wow.
Is this a good impression?
Is it
For
social work?
members of the public? It wasn't a good impression for me.
Is it your class of social
And so
work?
even a question that we raised earlier, if we're not able to call ahead of time and find out if a case is open or not, are we going to go down and just kind of,
We have special set cases in Bartow. You can bring your class to us.
okay,
But we'll tell you when we have a specially set termination, and
Oh,
you
thank
can
you.
come.
But you do raise a good point, because the bottom line is you may or may not know. You may not know ahead of time. I mean, unless the hearing was ahead of time, then that was ruled on and it was set. Then if you call down there and they say, we've got this case on the calendar, they may not know whether it's open or closed yet. That's one of the things I think judges are trying to work through. Now, Judge Sumner is going to handle it a very specific way, and he's being very proactive. But there's not 159 of those protocols out there. People are still working through that.
but if they've had a case that they've been continuing for months and it's January, they should
It's not
know.
open. That one, it couldn't.
They should know. I mean, they should know. In this case, they should know.
Well,
You
now,
know, they don't. Everybody doesn't know that it applies, and maybe some aren't interpreting that way, that it applies to cases filed after January 1st. Some may not interpret it that way. People are feeling their way through this.
yeah.
Because there's not a case that specifically says that's what it does. Those of us who are applying it that way are going by a similar type of legal theory. I mean, the law is just, it's not always as clear-cut as one would think it ought to be.
Let me make one more observation, too.
But this was very clear cut.
Well, let me make one more observation, too. I understand your frustration, because it is the law. But now, let me say this.
Which is frustrating.
The courts that have been open to the public and the press in the past, they're used to this. They have infrastructure to deal with this. The Superior Court is used to getting this kind of stuff. Juvenile court is not. And I'm rooting for you to get us some financial resources, to get us some people who can help us with this kind of stuff, because it's not built in to have people that address all this stuff. And especially, I'm from a rural county, and I brought my entire court staff with me today. Well, it's me. That's it. So I'm just saying. There's going to be some growing pains with this. So I understand your frustration, but you're going to have to be patient while we work through this.
Did you say you were with a Kennesaw State? Is that what you said? You have a class? No. Okay, because I was going to say in Douglas County, we do allow folks in for educational purposes. And before the courts were open, the judge, both of them, would, advise people, these hearings are confidential, you can take notes and that kind of thing. And it had to be for educational purposes. My second comment is that we had a hearing, and it was the only hearing in the afternoon, so everybody was pretty much gone. But there were a couple of people in the back of the room on the benches, and one of the attorneys, when they heard the door open, turned and said, "Judge, can we find out who just came in the courtroom?" She said, "No, it's open. They're allowed here." And the attorney was a little upset about it, but so we did just let them come in, and they were in the wrong place. But they weren't even interested in hearing the case. They were in the wrong place. But, the attorneys were concerned, and we just left it open.
I did want to tell you, we only have 2 benches, though, in our gallery. Everybody, just don't turn it off.
My question is, as judges, have you explained any of this? Like if, a case comes in, like we're just not talking about it. I think we've just, besides us workers in the court, we're going, oh my gosh, there's people in here. Like we come in and there's no telling the people, the clients, well, now the courtroom's open. In case you see somebody back there, you don't know who they are. There's really no explanation. So I'm wondering if, as we're getting trained on this, we need to train our attorneys and our CASAs and caseworkers to all then be explaining that to the clients and families as well.
Absolutely. It's obviously the training's not occurring as fast as some want it, but it's getting out there. This is part of that. This is part of that training, is to get out what the law is, and then just to hear what the questions and concerns are. We're learning today. I've learned stuff today that I haven't even considered before. So, juvenile court this is just a radical change. I'm not saying it's bad. I'm just saying it's radical, and we're having some growing pains with it. But yeah, all of us need to take ownership and communicate this, because this is the law. This is it. We need to get it out there, and this training is part of that process.
And your people are committed to doing this and doing it right. And you've brought to our attention, issues that we had not thought of. And there are clerk issues and staff issues that are really not that have not previously been judge issues, and so now you've made us think about those, and that's very helpful.
I have a concern. A comment first.
Oh, I'm sorry. Go ahead.
I'm glad that the law I'm a social worker, and I'm in a private agency, but I used to be in the system as a social worker, and I get concerned. I get invited to court by families that I work with. And I've sometimes had problems with getting in, and I've had caseworkers say to families, they're not allowed. She's not allowed. She can't come. So I go anyway, and I do get in most of the time. My concern is that for a family, and I'm glad for the hearing, because for a family that wants that kind of support by an agency that they've been working with on an ongoing basis that can shed some light on some things related to that family, I think that this will help us
right.
to be more involved and connected to this process.
Right.
Thank you.
Okay. Let's chug ahead a little bit. We'll come back to some of these issues, but we're talking, this part is request for use of electronic transmission, videotaping, motion picture, or still photography. The law did not change here, okay? It's still governed by 15.110.1b. So that part is not changed. But if the press is admitted to an open hearing, you mentioned this a minute ago, the court may order the media not to release that identifying information concerning the child, family member, foster parent, or the caretaker. Now, once again, we made this point earlier, but I want to make it again. That restriction is for the media. Okay, if it's open to the public and somebody's in there, we're gonna have to, I guess, plead with them. Please, for the sake of this, don't just go taking this around. Any thoughts about that? You want to?
No, I've thought about, though, issuing a blanket order on that, kind of a standing order that says the media shall not in any case. Now, whether that has any validity, and posting it on the door, whether that would have any validity, I don't know. But it was, or we have a similar. We have a HIPAA order that we put in every single file. I'm not so sure that I might not do that. Mm-hmm. Of course, you don't have the media there, so they don't have personal knowledge of it, but it would be easy enough to have one ready to generate anytime the media is present so that we could protect that.
I've had a personal conversation with some of my reporters, and they've just agreed not to do it. You know, and they've seen that really they didn't have any problem with that. But you know, that protection is there. We have concern. I mean, some of us have concern about what might happen by a third party. We don't know. I mean, I don't know of any case where that's happened yet, but it is potential, and it is an issue to think about. The general public, even under the open law, the presumptive open law, is still excluded from these hearings. Delinquency first-time offenders, not covered under the new law. Unruly offenders, it did not address that. Emancipation proceedings and parental notice of abortion proceedings. Now, Judge Till and I have racked our brains. If you can think of something else, please tell us. But that's kind of the list we've come up with on this. If there may be other things, if you think of anything, please let me know or shoot me an email. But that's what I'm stuck with right now. Now we come. Yes.
Karen wanted us to take a 10-minute break, and that looks like a good.
Okay, good. All right, we'll take it. You want us to? Karen's got an announcement to make, but we're going to take a 10-minute break, and we'll come back and we'll pick it up with public inspection of files and records.